mentioned, I'm a partner in the law firm of Holland & Hart. My expertise is information technology, contracts, and data security. I've worked in this area for about 17 years. Today, my goal is to go through some technical and contracting issues regarding healthcare IT contracts and electronic health contracts. Some of those things are going to involve risks and issues that we've seen over the last several years. We're also going to be talking about legal issues that arise in the contracting process. And to me, most importantly, I like to talk a lot about the process itself, from the process of scoping out the project to vendor selection to selecting the right team. Because as we've gone through and had experience negotiating these types of transactions, both on the provider side as well as on the client side, you kind of see some consistent issues that arise, and I think we could all benefit from sharing that information. So with that as the background, starting with some key issues that we run into across the board, a recent risk assessment performed by Chan Healthcare reviewed over 4,000 risks in healthcare affecting more than 280 healthcare entities. They grouped those risks into 5 general categories, and the categories were high level. They include care transformation, compliance issues such as HIPAA, information technology, healthcare operations, and revenue cycle management. Those are probably all topics that you're familiar with, but when they dove deeper into what was contained in those categories, they identified 20 top risk areas. And the survey was performed last year, but they identified those as concerns for 2017. Of those 20, 9 are directly related to IT systems and electronic health records. Those include HIPAA compliance, cybersecurity, systems implementation, access management and use of credentials, controls, vendor management, clinical documentation, both in terms of its security, its appropriateness, etc., case management, and patient access. Now, another study we look at in the cybersecurity world is the Verizon Data Breach Investigations Report. This is a report that is put out in a few various formats. Some look at worldwide issues, some look at things domestically. But in that most recent report, in the healthcare section, they identified a number of risks to healthcare on the data breach side. They analyzed healthcare and said, one of the big issues with healthcare is they have to protect a large amount of personal data and medical data, which is the utmost in sensitivity, and also provide very quick accessibility and data integrity to the medical professionals that need it most. One of the interesting things that came out of the study is that if you look at the risks presented by healthcare on the data breach side, 32% of the data breach instances in healthcare involved external threats, such as hacking. 6% involved partner breaches, such as the use of third-party service providers to handle IT systems, but 68% resulted from internal risks, those being employees mishandling information or acting as bad actors. When they analyzed the actual data breach incidents in terms of their causes, most were related to misdelivery of data, where it went to the wrong place, was sent to the wrong place, it was accessed by the wrong people. To a lesser degree, things like disposal areas, which are the stories you've read about in the news involving sometimes seeing files winding up in dumpsters, et cetera, was a much smaller subset. Loss of those, even smaller, and then publishing errors and misconfiguration rounding out the list. So when we take those risks and talk about how do we address those risks when we go to contract with any type of service provider, whether you're talking about the electronic health record system or you're talking about payroll processing for any type of business, the normal laundry list of key contract issues is here, and that includes the big ticket items that we're all concerned about: indemnification and risk allocation, confidentiality and non-disclosure, the warranties and disclaimers, limitations on liability, how to handle disputes, termination, transition, both into the service and out of the service, and wind down, and then intellectual property ownership, licenses, and disputes. But I think when you get beyond those, I think there's a much more significant list that addresses the day-to-day issues that you run into in contracts. And many times the timing, the urgency to get the solution in place, those issues, which are certainly fundamental to the contract and important to the contract, sometimes overshadow these issues, which ultimately have to do with the success of the overall solution. So I'd like to spend a little bit of time here talking through these. The first item on the list is what I would call implementation issues. When you talk about how to get from where you currently are as a provider and bringing in a solution, a third-party solution that's going to help you manage electronic health records or some kind of IT systems, the implementation process and how you capture it in your agreement is critical. As part of that, the factors that influence a successful implementation include the timing. And when we talk about timing, one of the biggest questions is your timing realistic? In order to determine whether your timing is realistic, it's important to consider how much are you integrating, how much of it is a change to what you're currently doing, and how fast are you doing it. The biggest risks I've seen is when an organization is looking to implement a solution quickly because their needs require it. But sometimes that implementation allows them to miss some of the gaps early on, and that ultimately leads to failure during the implementation or delay. A second piece is clearly defining the roles and responsibilities of each party. You often see this when a service provider comes in and says, okay, we're going to identify what the risks, the assumptions, the dependencies, et cetera, are to the implementation. The critical part of this is a lot of the IT service providers, appropriately so, use what's called a RAID nomenclature, or at least that's what I call it. It's a methodology in project management that says, okay, let's identify risks, assumptions, dependencies, et cetera. And when you go to put those in a project plan or in a contract, in a project plan they make perfect sense. In a contract, many times these are stated as things such as, you know, this project assumes that the facility already has a certain level of IT functionality, certain personnel will be available, et cetera. But where the contract or the implementation can fall apart is when you translate that over into contract language, it's not always clear what that message means or what that assumption means. As an example, by just stating that that is an assumption, it doesn't necessarily make clear who is responsible for making that assumption become reality. So my recommendation here is always to say, okay, if we've got generalized assumptions or generalized dependencies, we need to break those down into actual roles and responsibilities. So if we say the assumption is, you know, assume that the environment is set up and ready to go, it has a certain amount of power, it has a certain amount of telecommunications capacity, et cetera, normally the implication of that is that the customer is responsible to provide that. So to make that clear and to make it clear to the people whose job it is to meet that obligation, it's important to clearly identify it as such and say, okay, if you're the hospital that's buying the solution, The hospital is responsible for making sure that you've got a certain amount of connectivity, et cetera. This goes across the board with every single task and responsibility that's part of the implementation. The ramification of not clearly defining those is that those assumptions, if not met, can be interpreted to be contract conditions, where the provider will say, we identified this as an assumption. That assumption was not met, and they claim that they are excused from performing, or that requirement or that assumption was a dependency that now delays the project, it increases cost, and it has downstream effects on all the other requirements that you need to fulfill in order to implement the solution. So roles and responsibilities are very important. Milestones. As part of the implementation, it's important to identify the sequencing of the various pieces of the implementation. In many of these solutions, you've got a choice. You've got a choice between doing a cloud-based solution, a software as a service-based solution, et cetera. And those solutions require different sequencing to implement. In some cases, you may need to bring certain hardware or certain software into your environment to make them work, even if the provider is providing a solution over the internet. Those components of the solution many times need to be set up in a certain sequence, or there's a logical sequence to where you need to have certain things set up before other things are set up. Milestones, by breaking up the project into pieces and identifying milestones, you can track progress. And ultimately, I think it's appropriate to make sure that any implementation fees are tied to those milestones. We don't want to be stuck paying a large upfront fee for an implementation that covers the entirety of the implementation if the provider is missing those milestones. We'd much rather stage it out in some way to where there are milestone-based fees that are tied to completion of those milestones. And along the way, you can conduct acceptance testing. So we're going to turn to acceptance testing now for a moment. As part of the implementation, each major component of the implementation should be tied to some form of acceptance testing. In some cases, that's just confirming that certain items were delivered. But when you get to the technical side of the solution, it means actually testing it to make sure it does what they say it's going to do. So up front, as part of the contracting process, it's important to say, for each component, each major component, what are the criteria that we need to test? What are the aspects of that component that are critical to our business that will give us the assurances that it's actually going to function the way it's supposed to? What is the scope of the acceptance testing? Now, we're talking about testing a lot of times from a very technical perspective, but acceptance testing also can be as fundamental as we want to be able to look at and review and comment on and ultimately accept the entirety of the implementation plan. That should require a sign-off before they dive into the implementation. So when I talk about scope, we're talking about not just scoping out acceptance testing of the technical solution and its components, but also documentation that's required along the way. Components versus the entirety of the solution. So there have been no shortage of instances where providers and customers in various industries have gone through an acceptance testing process, and they've tied acceptance testing to certain milestones, and they tested the various piece parts of the solution, only to find that when they got to the end, even though piece part 1 of the solution tested and worked, and piece part 2 of the solution tested and worked, they got to the end, and there was a hiccup in terms of how the entirety of the solution fits together. So it's important at the end to have your acceptance testing process address the solution as a whole as a final acceptance testing process. And then as part of that, your remediation can go back and say, okay, if something fails in the process, how do we resolve it? Because you don't want to flip over into a live environment, a production environment, where you have risks of data being lost, risks of data losing its integrity, or risks of not being able to access what you need if you could have addressed it in testing and remediated it early on. And lastly, a big component of the testing where you also can see gaps is moving from a sample environment or a test environment to a full-on production environment can also identify gaps in the solution or problems in the solution. So sometimes you might test on a purely test environment where your users might be fully accepting of the solution, it looks like it works, but then when you go to a sample user group where you're still not rolling it out company-wide, you might uncover some problems. And then in other cases, when you go from the more siloed sample test environments or small user groups to the enterprise environment, you can run into solutions that fail under a actual user load. And those are things you want to test as part of your acceptance testing process as well. So I've noticed as I'm talking that we've had a few more people join as I've been starting up. I want to mention again, just briefly, that if you have questions or comments or want me to elaborate on something, there is a chat functionality you can access at the top of the screen. There's a pull-down menu bar, so if you have any comments, questions, items you want to elaborate on, or even if you think I'm flat wrong on something, I'd like to hear the feedback. So that way we can have a little more of a two-way conversation here. So now, a next major component of these contracts that's not always in the big ticket list of issues is performance standards. My experience in healthcare IT contracting is that this is one of the areas where I've seen providers be maybe least flexible at times, but the good news is I think they've been improving over time. Historically, this has been an issue where they've been concerned about risk, which is understandable. The providers will say, hey, look, we're not healthcare providers, we're IT providers, so we're not going to assume responsibility for the business risk of healthcare, but that doesn't mean they shouldn't be responsible for the business risk associated with their product, which means their product should perform as agreed to. And one of the ways to address that is by addressing it in contract covenants, representations, and warranties, but another way is in the formulation of performance standards. So when we're talking about performance standards in an IT solution, some of the most common ways to address those are address issues such as availability. Is the solution available for use when you need it to be? There's different ways to define that, but I think for most healthcare providers, we'd want to be defining it in terms of a 24-hour day. There's other situations where businesses operate more on a business day framework, where you can say, okay, we know that you could be down from midnight to 2 a.m., so we can focus on maybe a higher level of availability, a higher level metric for availability that is defined by the business day. But in healthcare, I think it's important to say 24 hours a day, 7 days a week, because that's your business. Another type of performance standard focuses on integrity. And this is one that it becomes a little more difficult to put together an SLA on it. But at the end of the day, we want to measure accuracy. Is the system, and this comes into play both from a measurement perspective and from a standards and control perspective, where we want to make sure that the data that is inserted into the system or populated in the system, whether it be patient health records or any other kind of data, remains accurate. If controls are weak in the system or the system experiences a bug, that data can become corrupted, it can become inaccessible, or it can become, it can change but either by user error or something else. And in a situation like healthcare where accuracy is critical, measuring processing integrity or data integrity is very important. Response time and remediation time. I put these together, although in fairness, it can be pretty difficult to put a hard metric on remediation time. Response time usually comes in a couple different forms. Response time can be measured in terms of when you have a problem, how quickly does the service provider respond to that problem, get people working on the problem, and trying to fix the problem. Another type of response time is the technical response time, which is usually measured in milliseconds, where we say from the time if I'm using a computer system to access, a laptop, these days iPads, from the time I input an inquiry into the system to search for a record, to put information in, etc., how quickly does the system respond, or how quickly does it call up? You need these response times to be really fast, although for some solutions, depending on how it's architected, it's possible that the solution might rely upon hardware at the customer site, in which case some of the response time is based upon the hardware you're running, and the vendor may not be wholly responsible for that. Customer user satisfaction. This is one that I think it's always important to push for, because when we go through an implementation to bring in an IT contract, an EHR contract, that you're going to have a lot of different healthcare service providers using, from the doctors, the nurses, physician's assistants, staff people, making sure that the system is something that they can use, that is something that's logical to them to use, is important. So I think measuring user satisfaction, which is often done through some sort of survey, is important. These can also be done as soliciting responses. If somebody sends in a trouble ticket because they're experiencing a problem with the solution, they send in a trouble ticket, the service provider responds and works to resolve the situation, and then sends out some form of user review immediately in real time. You can gather that satisfaction. Oftentimes, those responses are aggregated over a month, over a quarter, over a year, and you set some sort of minimum threshold that says, okay, we want the vendor to maintain user satisfaction on an 8 to 10 scale, or on a scale of 1 to 10, of 8 or above. And if it falls below that, here's the ramification, and we want to know that there's a remediation plan in place, et cetera. So I think that's important to address. Once you've defined the types of performance standard and the particular criteria that you're dealing with, it's important to figure out how that's being measured. For things like availability or processing response time, if a vendor is providing a tool, a cloud-based tool, a SaaS-based tool, the vendors should have measurement procedures in place to measure those metrics. Some of those measurement criteria can vary. For example, there's a lot of service providers who might say, for availability or response time, we're going to start measuring that incident from the time you open a ticket. Well, for availability, the availability didn't necessarily start at the time you open a ticket. The availability started at the time the system wasn't available. So navigating and trying to agree upon what the starting and ending points are is important. It's also important to determine how those metrics are going to be reported. Are we going to ask the provider to aggregate those responses and deliver a monthly report? I think that's usually appropriate, but we also have to look and see what reporting mechanisms they have in place versus what you're asking for. Consequences and credits. So there's a few different ways to go about how to address these. Based upon the relative importance of each one of the performance standard metrics, you may want to put a credit mechanism that is attached to that SLA. This is very common with availability, very common with response time. The SLAs or the particular credit usually has some relationship to the fees, and the service providers aren't going to want to or typically refuse to go above that. So it's common to sort of say, okay, the credit mechanisms are capped at whatever 1 month's worth of the fees are, or some tie to that. There's certainly providers I've seen who take a much more aggressive approach. I think I said earlier that that's getting better, but it was not so long ago when you had providers say, we will give you performance standards in the form of service level objectives, but there are no credits or anything like that if they miss. I always found that to be a bit shocking, especially since things like service level credits are commonly used in every other industry, but healthcare seemed to be the one area where they were slow to adopt that. So when I say service level or SLAs, SLA stands for service level agreements, which is usually a separate component of the contract that says these are the performance standards where we're going to define a particular service level and measure and report on it. Sometimes you might have multiple layers of these. We might call the whole mechanism overall a service level agreement, but they might also be defined as an SLO, which is a service level objective. Service level objective is often one that is a performance standard that is tracked and measured, but there might not necessarily be a credit associated with it. So aside from credits, an ultimate remedy for service level failures is termination. Now, when I say remedy, it's not much of a remedy because it's almost like cutting your hand off. It's the ultimate penalty for the provider, and it's used more often as leverage in terms of having a backstop and saying, okay, if we have performance failures that become chronic or repeated, and we can talk about how best to define those. You know, sometimes they're defined in terms of if you miss the availability metric 3 times in any 12-month period, for instance, that might be something that might justify a termination right. That doesn't get the problem solved, but it gets you to a point where you can hopefully incentivize behavior by saying, look, if you don't meet these requirements repeatedly, I need to get out of the agreement. In between service level credits and termination rights, we usually also try to put in something that involves some form of remediation plan, some form of consistent back and forth that says, okay, if you miss a service level objective on a one-time basis, we know that sometimes it's going to happen. So one-time basis, you might be able to get away with dealing with it in the form of a credit. If it goes beyond that, we want a mechanism in there that says, okay, we want a root cause analysis to be performed anytime you miss a service level. And we want to know that there's a remediation plan in place to address whatever caused the problem and make sure that it won't recur. And that should be a part of the ongoing governance process of the agreement, is making sure that there are day-to-day or monthly discussions on how that's happening. So next up, so we talked about service levels. There are a number of other issues that are key to making sure that we're addressing the other risks in the contract that create gaps. Sometimes these are other things that get glossed over, so I want to make sure we spend some time on them. So the next one is compliance with laws and compliance with standards. And I'm going to talk about these kind of together. It sounds very mutual, very agreeable to say, okay, each of us will comply with the laws applicable to us. And that becomes tricky because an IT services provider isn't immediately subject to laws that apply to a healthcare service provider. I've also seen contracts where the parties have said, well, you're going to comply, you service provider are going to comply with the laws applicable to me as a healthcare service provider. That doesn't always work either because a law that regulates a healthcare service provider is going to make specific reference to, or often makes specific reference to, legal responsibilities of that healthcare service provider. Oftentimes in that law, it's not going to specifically say, here's what happens when you engage a service provider. So in terms of dealing with your own compliance requirements, it's important to actually define what are those things that the service provider is doing that is impacting my compliance, and include the more specific obligations that you need them to meet in the contract. It's a more precise way of getting to the same place, but if you only relied upon each of us comply with applicable laws, they can step away and say applicable laws means I'm not subject to healthcare laws. So making sure that that is clear is important. Compliance with standards is similar, although this is very often a place where you see a fight, where the provider has their own standards having to do with their internal controls, their data security requirements, their data security policies, maybe an acceptable use policy, et cetera. You as a healthcare provider, as the client, have your obligations under HIPAA, you have other legal obligations, you have your own IT standards, change management standards, data security standards, et cetera. So it's very common on the front end to wind up in a fight where one party says you got to follow our standards, one party says you got to follow the other. So it's important to find a way to bridge the gap, because you're not going to make the provider change all of their standards, but they do have to follow certain of your rules, and you have to follow your rules so that you're in legal compliance. The best way I've seen to do this is ultimately for both parties to perform a gap analysis and say, okay, for a service provider, what are those things in the healthcare provider's standards create a problem for me or conflict with what we're doing or require us to do something that is out of our normal process, and vice versa. And then you can deal with those tasks and responsibilities specifically in the contract. Data backup and disaster recovery. We talked a few moments ago about availability, and addressing availability from a service level agreement gets you to the point where you can say, if the service is down for an hour, you might get a service credit. But as we've seen recently with the hurricanes that have ravaged Texas and Puerto Rico and South Florida, we also need to address what happens if bad things happen. What happens if a hurricane hits, wipes out the data center that the service provider uses, shut the systems down? Do they have a backup? Do they have a failover? Are their data center facilities geographically diverse enough to where you've got failover protection? And how do they architect that disaster recovery plan? Do they have facilities already set aside at that data center, at that backup data center, so that they can snap their fingers if a disaster is declared and move your traffic and your systems over to that? It's also important to understand where the geography comes into play, because it impacts data security obligations. Now, we're concerned, I think for most of the participants on this call, with HIPAA, but as part of that, you also have concerns about what your service providers are doing with data. And if you are US-based and don't use don't have facilities outside the United States, don't deal with data that is outside the United States, and a provider is using a data center outside the United States, that's an important thing to know. It's also important to know if they use the data, where that data center is and where their other data centers are. Because you can inadvertently create an issue if you don't think through it, where suddenly you're transferring data outside of the U.S. that you never intended to a place that might impose upon you data security obligations that you just hadn't thought through. So understanding how the disaster recovery works, how the solution is architected, and where the facilities are located is important. Data backups, the frequency of them, how they're maintained, where they're maintained, and how they're secured is another component of that. Because one way to handle disaster recovery is for those disasters that might take a data center out. Another type of disaster might be some of the things we've seen in recent years in the data breach cases, which is what happens if somebody attacks you with ransomware. One way to get around that is with frequent data backups that you can resort to. If one database or one data set is locked up and you are backing up data frequently enough, you can restore from a most recent data backup if it's accessible and if it's timely. So those two items together help form the basis of your disaster recovery response plan. Service suspension or blockage. So a lot of times service providers like to include language in their boilerplate that talks about if a user violates terms of use, if a user violates the agreement, if they're not paid, etc., they can suspend service. There's also instances where they can attempt to block service for similar violations. In your industry, it's important, or in the healthcare industry, it's important to limit their ability to do this. And this may not become apparent from a first read of the contract. It may not be in blinking lights under service suspension. Usually it's addressed in some form of compliance with their policies language. It also can be addressed in, or actually it's not addressed oftentimes, but it should be in connection with any software where they provide, where if you buy a subscription-based solution, a lot of times that software or that environment that they have contains a timeout in it, a code that actually says after a certain time period, your access is going to automatically be cut off. Addressing those issues in the contract is another one of those items that you need to understand that that's a common requirement of an IT service provider, and we need to address the fact that it could have a very detrimental impact on your business. Governance and project management. So these are the terms and conditions that talk about how you're going to work together over time. And it addresses things like, what about changes to the solution from a technical perspective? You know, if a provider makes a change to the solution that impacts what your users see and feel and how they interact with it, that can be a problem if you don't know about it. It also comes up in terms of if you're having a problem, whether it be an IT services problem, whether it be a problem with one of their employees, et cetera, and also how to deal with contract management. What are the processes and procedures and mechanisms that you use in order to say, look, when we first entered into this contract, this process that we identified worked. We think it's not working anymore. We'd like to find a different way to adjust it. So addressing that is another key issue. Subcontractors and subservice organizations. Many cloud and hosting providers use third-party providers behind them. So if you're contracting with a cloud services provider to provide an electronic health record solution, many times they engage a hosting provider, be it Amazon Web Services, IBM, somebody else, to provide their back-end facilities. So they're almost sitting in the middle. They might be running the solution, but the IT systems might actually sit behind them. So when we're looking at these contract provisions, when we talk about compliance, we want to make sure that we understand everybody who's acting behind the service provider we're contracting with, and making sure that the requirements we need the service provider that we're dealing with one-on-one to address are also requirements that their back-end providers can meet. And the same goes for any other vendors or service providers involved in the process. So talk just a minute about the hosting providers. They may engage all sorts of other kinds of providers to provide certain pieces of functionality. And understanding where they are in the process is important, both from an IT systems view, a security view, as well as a compliance view. So, with all of those big contract issues to deal with, how do we address it? So, the number one way to address this is you start way back before you're even talking to a provider, and that comes in the form of due diligence on a service provider. So we're going to shift now to talk about due diligence, and this is highlighted as vendor due diligence, but we're actually going to talk about due diligence on your own organization. The traditional view of due diligence in the IT space has been, we already know what we're planning to do, we've already selected a vendor, we want to look into the vendor's financial viability, we want to look into whether they can really do what they say, we'll have them submit documentation to us, etc. And unfortunately, oftentimes the effort level afforded to diligence has usually been based upon the value of the contract, how much you're going to spend, without specific reference to risk. I've got a little war story that talks about that. It's not really in healthcare IT, but I'll share it briefly because I think it's a good illustration. So as part of my practice, I negotiate various types of contracts, usually for buyers, but often for service providers too. And there was a time when I was working on a contract that involved backup data storage tapes. And this was a contract where the supplier was going to pick up backup data storage tapes, they take them to a warehouse, they do it all on a secure basis. These types of providers generally like to say in their contracts that, look, we don't care what's in the box, we're not insuring what's in the box. So we are tying our limitation of our liability to how much you're spending with us. So to us, we're picking up a box with stuff in it. If you assign a particular value to stuff in it, you should get your own insurance for that. While I'm negotiating this contract, we're in a fight over different scenarios about what happens if the tapes disappear. And we were going through the law school hypotheticals of saying, well, what if your van driver pulls up to 7-Eleven after picking up the box, stops for a drink, and leaves the keys running in the ignition? Is completely careless about it. And we agreed in that call that, okay, that's a situation where if he walks out and the van is gone, that's the fault of the provider. That's a risk they should take, and in that case, liability shouldn't be limited to $5. As we moved through the different scenarios, though, we ran into one where we said, hey, what happens if, and how do we deal with the risk allocation if somehow the van arrives where it's supposed to? There were no keys left in the ignition at 7-Eleven, but they get to where they're going at the offsite storage facility, and the box of tapes is gone. We don't know why. We don't know if somebody broke in. We don't know if they're careless. How do we deal with that? And of course, on behalf of my client, I was suggesting, look, at the point we put it in your care, we think you're responsible for it. As I'm on the conference call, I had an assistant come in with my mail, which included a letter to me from a company called Mellon Bank. There was a data breach notification letter that said, we're writing to let you know that computer tapes containing some of your personal information were lost while being transported to an off-site storage facility by our archive services vendor. So immediately, our hypothetical situation became real. This particular data breach at Mellon Bank affected, I think the final number was around 14 million people. But the point of the story is to point out that sometimes the higher risk activities, the things that can produce most liability, can have zero relationship to the dollar value of the contract. because in that case, the backup data storage provider was charging maybe $1,000 a month for those pickups, but it led to millions of dollars of liability for Mellon Bank. So instead of tying the diligence effort to contract value, it should be tied to risk, and risk of HIPAA breach exposure, risk of harm to customers, employees, consumers, harm to your reputation, the distraction value that comes after a data breach, where your people have to spend time, instead of doing what they do every day, dealing with the impact on the business. And that's without even counting the cost of investigation, notification, remediation, lawsuits, or regulatory action. So I've identified a few key points in here along the way. This is a rehash of what I just said, that because business owners are often thinking about the dollar value of the contract, the cost savings of using a provider instead of doing things in-house, et cetera, we want to match the solution to the risk. So, and in doing so, from a contract perspective, the standard that we usually talk about in terms of data security is reasonable or reasonable and appropriate, not commercially reasonable. That's a legal distinction because in a lot of contracts we use the term commercially reasonable, which is typically tied to the idea that what is reasonable for a normal, prudent business person to do, and it has some tie to the cost of doing it. The standard in data security is reasonable and appropriate based upon the sensitivity of the data you're dealing with. And in healthcare, we're dealing with sensitive data. So why conduct due diligence on service providers? Well, in the previous Verizon data breach survey, they found that 97% of breaches featuring the use of stolen credentials were stolen because of legitimate vendor or partner access. And overall, 63% of data breaches can be attributed to a third-party vendor. Many times not directly, but where their access point was leveraged to get into the environment. That was the case with the Target breach, the Home Depot breach, et cetera. So once you understand the risk when you're contracting in IT and electronic health records, it's important to make sure you align your needs with the actual product and service offering. We've got to guard against the risk of the vendor coming in with a fancy new solution that looks great, but may not necessarily align to what you actually need. Aside from the implementation issues that I talked about, the biggest issue I've seen that required fixing in these types of contracts is a lack of fit from the beginning, which is a lack of fit between what the vendor is actually providing and what the business actually needs. So as part of that, you need to analyze the risks and benefits of what the trends and developments are in the space that you're working in, between an outsourced solution, between cloud services, whether certain things require a dedicated environment, et cetera. And also balance that with which of those solutions helps us with our compliance with legal and industry obligations, and how do they help us mitigate risk. Okay, so when we're conducting due diligence, I like to think of it in three places: what you do before the contract, what you do during the contract, and what you do after the contract. Diligence starts on your side with your business. Before you're even talking to a vendor, it talks about what do you have now, how are you doing it now, and what are your needs for the system? What do you have in place? What facilities do you have? And who are your current suppliers? We don't want to do something that creates a solution that nobody on your team will use, or is it too hard for them to use, or ultimately, because you haven't looked through all those issues, even though on paper it looks like you're saving money, it actually takes away efficiencies. To do that, it's important to establish what your project objectives are before you're ever talking to the vendor. Identify in detail the functions that the vendor is going to perform, the service provider is going to perform. Specify who you think is responsible for that, somebody on your side or somebody on their side. And in addition to describing the objectives, what are you trying to avoid? So instead of just thinking in terms of what do we want to get out of it in terms of accessibility, et cetera, what do you want to avoid? Is there an experience with a past provider or a past solution that was a bad one where you say, we don't want that? It's important to consider that too. It's also important to establish a financial baseline that's realistic. So what is this going to do to the costs? Is it something where you're trying to reduce costs? And how does that relate to your current run rate? What are the service levels or performance standards that you want to measure? And are all of these objectives that you've defined supported by your senior management? Because ultimately, when you bring in a new solution, in addition to securing high-level buy-in from management to the solution itself, you ultimately need to get buy-in from your user base. Because if it's not successful in terms of that implementation and user adoption, you're going to have other additional problems as you move forward. So as part of that financial baseline, you need to estimate the costs of performing those functions yourself and compare those to what the outside service provider can do. And we talk about applying a discount for anticipated savings. I think savings sometimes is oversold as a benefit. I think you can achieve savings, but I don't think I think oftentimes it's used as too much of a driving factor. That leads to disappointment when those savings aren't actually realized. So I'm going to shift for a moment and talk a little bit about data specifically because of the sensitivity of the data we're dealing with. And as part of dealing with the data, we want to understand everything we have about that, we know about that data in the diligence space. That means identifying what data you have, where is it collected and how, at every touch point. What do you do with it? Where do you have it? Where do you keep it? Who can access it? Who needs to access it, both internally and externally? How long is it retained? And ultimately, how do you get rid of it when you no longer need it? So how do you answer that question? From the very beginning of the project, from its inception, you need to include the key folks from every aspect of your organization. IT, any subject matter experts, your financial folks, tax, HR, risk management, and legal and outside consultants. So I want to take a quick moment to talk about legal and outside consultants. And my favorite of those is Patches O'Houlihan from the movie Dodgeball. This might be an extreme example, but oftentimes, even though they can be costly, for a lot of these implementations, it helps to bring in somebody from the outside to drive change, to offer an outside perspective, and you might be able to recommend solutions to you that you might not see. Because you might look at something that is shiny and new that a service provider brings into your environment, says this will be great for you, but without doing the underlying diligence, which oftentimes an outside IT consultant or electronic health records consultant can do, and really say, hey, look, that solution could work for you, but based upon how you operate, based upon your facilities and how your users work with the system, there might be some better options out there. So I think outside consultants certainly have their value. And they should be part of that overall team that should be brought in as early as possible. You also need a strong leader with the support of senior management who actually has a belief in the project. As part of putting that team together, it's important to define roles and responsibilities so everybody knows where they are and what their role is. Facilitate regular and open communication. And I think it's really key to enforce organizational discipline. I've seen it too many times where you enter into the negotiation process with a service provider. They have their sales team that has some relationship with somebody in senior management. So while you're trying to get what you can get in negotiations, or your legal team and your deal team is working on negotiations, sometimes those efforts can be undercut by conversations happening outside of the negotiation room. So sticking to organizational discipline is pretty important. So what is the impact of time? I think this is a key component of every deal that we need to think about. I've already talked about performance standards being a key driver and those other things that fall outside the biggie contract issues that you don't normally think of. Another one is time. And starting early gives you an opportunity to make sure you've identified all the key risks and issues. I think outside of gaps between the services offered and what you really need, trying to rush through the process or get something done with too much urgency means you wind up, rushing over issues that can actually cause your implementation to fail. So being cognizant of the impact of time is important. It also is important in terms of the deal flow cycle. Sometimes you can benefit from a service provider who's trying to close a deal at the end of the quarter, and it might allow you, if the timing works that way, to obtain concessions at quarter end that can help you. It can also work in the opposite way. Sometimes you have service providers who are not focusing on whatever industry segment you're in or your size segment, and that means they may devote a little less attention to you, but when they're trying to expand their exposure to a particular industry segment, those things can help you as well. Okay, so now when you shift over into pre-contract diligence, you need to focus on what on the vendor itself. You want to know them, they want to know you. Important questions to ask are, how long have they been providing the solution? What does their organization look like? What's their experience level? And what's their reputation? How do they respond to problems? And then when you get into the data-specific elements, it's important to know everything about data protection. What are their policies? How do they handle employee training? What is the adequacy of their system, physical, and network security? Do they have business continuity disaster recovery plans, and are they consistent with your business? Do they have a tested data breach process? Do they have audit capabilities so you can make sure they're doing what they say? And who else are they accountable to? Have they obtained any type of certifications that are relevant to you? And will they maintain them? So what are your tools? Well, you've got non-disclosure agreements. If you've done your pre-contractual stuff right, you've established your criteria for selection in terms of what's important to you. You might have developed an RFP that identifies all those criteria. And then when you put the RFP together, require very specific responses from the vendors so that when you go to contract, they can't step away from what they said. With your team, it's important to funnel most of the communications through one or two people, so there's a primary point of contact, so that there's not people moving outside the work stream. I've seen successful implementations work because they held bidder conferences and meet to offer additional information to the bidders, which helps them refine their proposals and present them. And take the time to talk to their reference accounts. If possible, ask them to identify a situation where they didn't do so well. That's very hard to do, but it would be an important reference point for you. Come up with some clear and rational selection criteria so you can really weigh the vendors against each other. This includes experience, expertise, what are relationships they have, what are their available resources. Shouldn't just come down to cost. What's their general reputation? Are your corporate cultures compatible? What does the business look like from a financial perspective? And are they in a mode to be acquired or be an acquirer? So with that as the background, you can enter into the contract negotiations. Your diligence effort doesn't stop now. It just digs a little deeper. So you've got answers from the RFP. You've got all the information you've gathered to date. So it's important to now challenge their assertions, because sometimes you can have a big gap between what the sales team was describing to you in the RFP process versus what they're saying during the contracting process. Within your team, it's important to identify your primary negotiating team. Making sure you understand the importance of time here means set realistic timelines. And consider the use of a term sheet prior to getting into the contract so you can crystallize the key terms that you need to address and maybe reach agreement at a high level on those before you start drafting the contract. That can ultimately save time. It's important to empower your leadership on the negotiating team with the ability to make decisions. And you also want to insist that the vendor has the same. It can often delay things when you've got your whole team together and many issues need to be escalated to people outside the room who don't really have the background. That causes delays. It makes it hard to move forward in a timely manner. I mentioned this point a little bit before, but it's important to make sure that the management of your organization understands the risks that the vendor kind of trying to run outside the deal team, how that can impact the deal, because it really undercuts the negotiation and makes it harder to get the terms that you need in the contract. Understand the practices both in your industry and in the IT industry. Sometimes those expectations can be a little bit misaligned. And try to identify the big issues early. Oftentimes, we mentioned at the outset, the risk allocation stuff, indemnities, et cetera, are left to the end. But it's important to understand where the gaps are early on and understand what each party's position are so that you're not dealing with those things at the last minute. You want to know early on whether there's likelihood of getting to a deal or not. So from a leverage standpoint, this is hard to do, especially if we're talking about a smaller installation, but it's important to always make sure the vendor knows that you haven't settled. You can leave the door open to move to another vendor or abandon the project. If they know that they're the only game in town, they're going to act like they are. The same is true if other vendors remain in play. Now, this can be harder and more expensive to do, but the more successful negotiations I've seen in terms of getting the terms you need involve identifying after the RFP process maybe a primary vendor and a secondary vendor, getting them to submit their terms, both of them, before you down select to those vendors, and then sort of saying, okay, we're going to pick you as our primary, but we've got a secondary person here who's ready to step in. So if this goes off the rails or if we identify deal stoppers, we're going to step away and we're going to move to number two. It's important not just to say that, but to have the expectation within your team that you will pull the plug if you need to. And being able to socialize that with the vendor can ultimately give you leverage. I think it's important to avoid any public announcements about the deal until it's signed. The vendors are always going to want to say, hey, can we use you as a reference client? Can we do a white paper with you? Can we list you on our website? Those are things that you can address from a business perspective, but we don't want to do it before everything's done. I think it's also to avoid the letter agreement that says, hey, we're going to get you up and running, and we'll figure out the details later. This ultimately, it might get you a solution implemented faster. It doesn't mean it'll get you a solution implemented well. It also lets the vendor in under your hood within your organization before you're really ready and before you've actually addressed the contract issues. And once they're already in the door, it becomes much, much harder to address those contract issues. So as part of the contract, we talked about the key issues. Another one is to understand the impact of change in law, in technology, in your business, in your locations, in your personnel, and in any of your operations on the contract, and address those. Change provisions are usually put in place a process for how to deal with them, and it's important to think through what the impacts of those things might be. So now you get through the contract negotiation and you sign the deal. Are we done? No. The job doesn't end because now we need to stay vigilant. We've got to continue to monitor and enforce compliance. So your leverage in the deal essentially goes away after you've signed. There's certain things that if we did our job right, if we've got milestones, if we've got performance standards, if we've got implementation milestones that are tied to payments, and ultimately, if, for example, the implementation isn't successful, if you have a walkaway right, which again is something you may not ultimately want to do, but it's something you can put in the contract to create leverage, you can have those things, but your key leverage of are you going to engage with them or not goes away after you sign. So having the mechanisms in place to monitor and enforce compliance help tremendously. And that goes two ways. It's not just keeping tabs on the vendor, it's also making sure your people are following the rules you've put in place. Because many controversies have come in terms of these contracts where it becomes a he said in terms of what the service provider is dealing with and the employees of the customer are dealing with, where the reality is there's probably fault on both sides. So that's why monitoring enforcement applies to your very own people. As part of the contract process, make sure you get performance reporting, verifications that any certifications are in place and remain up to date, some form of financial security and control audits, again, depending upon the service provided and the solution, the ability to conduct your own audits or certifications if you can, periodic review of response and remediation plan, and with respect to all of those things, it should not just be they deliver the documentation. You should retain the ability to follow up, ask questions, and get the ability to validate. So bringing on a new vendor means sometimes an entire shift in process and procedure. So it's also important to make sure you can educate your people on what's the impact of the change in them. Offer training, and hopefully get training from your vendor for your people so that they can have buy-in on the solution, because you need to have your users trained on it so that it becomes an effective solution for you. Make sure you've got a governance process that allows for ongoing communication and training of all the key stakeholders, and that means communication both with the vendor and yourself, as well as your employees and any constituents of the solution. And make sure to revisit policies and procedures as you go to make sure that when you're dealing with changes in law, changes in technology, those policies and procedures can keep pace. So as a reminder of our key points that we've covered today, it's important to focus on the risk to the business when performing diligence, when doing your project evaluation and negotiating the contract, not just the cost, not just the urgencies. Make sure to match your needs and what you're looking for out of the solution with what they're offering. It should all start with you, and make sure your business doesn't get lost in the process under the drumbeat of all of the pretty marketing materials they provide to you. And make sure that you continue to be diligent with your team and in managing the vendor throughout the process. I think those are the key points to keep in mind. So if anybody has any questions, I'll be on for a little further time period. I want to thank you for joining me for the webinar today. If anybody has follow-up questions, I encourage you to reach out to me at rdspildy@hollandhart.com, and I'd be happy to answer or address any follow-up things, or if you want to see any aspect of the presentation materials or sources, I'm happy to share them. We also have at Holland & Hart, as some of you know, a healthcare group headed by Kim Stenger and Blaine Bernard. Kim Stenger in our Boise office, Blaine Bernard in our Salt Lake City office. So I want to make sure that, and I'm a part of that from a transactional perspective. So questions that relate to compliance issues, et cetera, can be addressed to any of those folks. But once again, thank you for joining. I hope this was informative for you. If you have any questions, comments, issues that we could address in future webinars, I'd be happy to take those.